Hello, and welcome to the webinar today. I'm Leah Binder. I am President and CEO of the Leapfrog Group. We are a national nonprofit founded by employers, like many of you, and purchasers of health benefits who back in the year 2000, 21 years ago, thought that it would be a good idea if people could compare among hospitals and health systems before they sought their care. And 21 years later, we have launched really a revolution in the way people think about their ability to so-called shop for healthcare, get the right care at the right price. So today we are talking about an issue of great concern to employers and their health benefits. And we felt that it was so urgent that we called it a compliance alert, because there are actually some major issues that employers need to be looking at right now. And from our understanding of the many employers involved, both with Leapfrog and with many of our colleague organizations, I'm going to introduce momentarily, we are finding that they are not aware of these major issues that are on the horizon. As a result, we felt that it was important enough that all of us would come together and give you a sense of what they are and what you should be thinking about. And at the same time, this will be the launch of a larger series of webinars, which we will all be doing to address some of the topics that you're going to hear today. But the most important thing for you today is to pull out your notebook and take some notes about the kinds of issues that you need to confront and need to address pretty much right away to protect you and your company. So I want to thank right away. I want to thank my panelists, my co-panelists, for joining us today and to give you this information and an opportunity for a discussion. At the end of the presentation, there'll be ample time for questions. So please put your questions in the chat and we will hope to get to as many as possible. And there'll also be follow-up communications afterward to answer any questions that we didn't get to, and also to give you resources and information about further webinars on the topics that come up today. Again, all of these are free. They're available to you as hopefully most of you as an employer, but anyone who's involved in Leapfrog or any of our organizations as co-sponsors of this webinar, you're welcome to join us and to be part of this conversation, so we make sure that we are addressing the Consolidated Appropriations Act appropriately, effectively, and with all eye toward compliance and making sure that employers are in the best possible position to address this. So let me introduce our speakers today in our panel. We have James Gelfand. He is the Executive Vice President of ERIC, the ERISA Industry Committee, which many of you know very well, one of the most effective advocates on Capitol Hill and in Washington for the interests of employers around health benefits. We also have Jamie Greenleaf of Tilt. She's the president and founder, and Mike Thompson, who's president and CEO of the National Alliance of Healthcare Purchaser Organizations. So we have an incredible lineup of some of the best speakers we could possibly find on this topic for today to tell you not only about this compliance alert, but where it came from and why it came out, why we have this new law that is of such great importance to employers. So what we're going to start with is Jamie Greenleaf is going to give us an overview of what this entails and what are the key compliance issues for employers. Then we'll have James Gelfand, who will comment on where this law came from and his work here in Washington in particular, how this came about. And then Mike Thompson as well will comment on some of the provisions as he sees it from the employer perspective, and I'll offer a couple comments as well at the end. And then we're going to open it up to you for your questions. So with that, let me hand it over to Jamie.
Great, thank you so much for having me today. Before I get started, I just want to make sure that you can see my screen, because that's the worst thing, right?
I can see it.
All right. Excellent. So Malcolm X said, education is the passport to the future, for tomorrow belongs to those who prepare for today. My hope is that we give you the knowledge and the tools to prepare you for what you're going to be required to do under the new Consolidated Appropriations Act. Yep. Screen going here, sorry about that. So the intent really is to help ensure that you have regulatory awareness, that we're helping you to minimize your liabilities, and that we're going to help you improve the outcomes of your healthcare plans for your employees. I thought it might be helpful to frame our discussion in a way that might feel familiar to some of us. For those of us that offer an employer retirement plan and or sit on a retirement committee, you might remember when the 408(b)(2) regs came to fruition. Prior to those happening, you'll remember the retirement programs had an overload of fund choices. They had commission education tools that had a lot of ancillary products being sold to employers. The average cost to an employee in a retirement program was running anywhere from 250 basis points to upward of 325. And those fees were really eating returns. We had low participation, and we had major company liabilities. The outcome prior to 408(b)(2) was really lawsuits, and unfortunately, those cost us as employers tens of thousands and millions of dollars. After 408(b)(2), we had this prudent process that we established. We had an appropriate fund lineup. We customized our education. We had lower expenses with the averages being below 50 basis points. There was transparency, better education, better plan design. Today, we have the average account balances over $100,000, and employees are able to retire on their own terms. What changed in the retirement industry is the same thing that's changing in the healthcare industry, and that is the addition of transparency. So there are three pieces of legislation that are coming to fruition. The first one is the hospital pricing transparency, which actually started January 1st of 2021. And it required hospitals to provide estimated cost prior to a person seeking the service, and the ability for that individual to actually shop that procedure. Unfortunately, there is a low number of hospitals in compliance right now, and penalties are being raised for those out of compliance in the year 2022. The CAA is actually 6,000 pages with about 200 addressing the healthcare industry. And that may be why so few of us are really talking about it, because it was such a massive undertaking and such a small amount of it was focused on the healthcare. And that's really where we're going to spend our time today. And then the transparency and coverage is really going to be a promotion of consumerism to the end user. So providing cost of care prior to an employee or individual seeking care, and giving us the tools to shop for those procedures. I want to remind you that this is bipartisan support, the Consolidated Appropriations Act. It was signed into legislation under Trump in 2020 and is being enforced by Biden. It's provided clarity, or it's was created to provide clarity for plan sponsors around cost, accountability, and services, to provide employers with access to their data to act in a fiduciary capacity, and to provide more aggressive enforcement for the Federal Mental Health Parity and Addiction Act of 2008. It's really putting a big F into fiduciary for healthcare plans and the process that employers use to make decisions. Now, rather than drinking from a fire hose, because as I said, there are 6,000 pages, we really wanted to focus on 4 key areas on a high level. As Leah said, we're going to be doing additional deep dives into each one of these in our series of webinars. But the 4 areas that you need to be aware of is the removal of gag clauses from service providers, contracts around quality and information, You're going to have to establish new reporting requirements on your pharmacy spend. The requirement of disclosures of direct and indirect compensation from all service providers. And it's going to require parity in substance abuse and mental health benefits. Now, although there are 4 areas that need to be addressed, there are 2 areas that are urgent that you really need to focus on before your renewal in 2022. The first is the removal of gag clauses. The second is making sure that you're receiving your provider's disclosure notices and determining if those services and fees are considered reasonable under ERISA. So let's focus on the 2 that you need to really be aware of today. Let's face it, any legislation that puts language like prohibits the use of gag clauses has to make you wonder a little bit. But the CAA prohibits health plans from entering into contracts with healthcare providers, networks, associations of networks, TPAs, or others who offer access to networks of providers if the contract restricts them from providing provider-specific cost or quality of care information or data through a consumer engagement tool or other means. To referring providers, the plan sponsors, enrollees, and individuals that are ready to be enrolled, you must have access to your data in a de-identified claims file that provides financial information such as allowed amounts and other claims information from a financial standpoint, provider information, including a name and clinical designation, service codes, or any other data elements included in claims. And you must be able to share this information with described business associates defined under HIPAA. So in a nutshell, any language that prohibits you from using your data to benchmark and or shop for better services needs to be removed from your service provider's contracts. The question that I always get is, what does a gag clause look like? So here's 2 examples of a gag clause that we have pulled out of contracts. You'll notice that the predominant word is proprietary materials. So these are examples of things, property of the carriers. These clauses no longer can be in your contracts. So what is your first action item today? You need to closely review your TPA and other providers' agreements for gag clauses. They have to be removed by December 27, 2021. You will, as a plan sponsor, need to attest that these have been removed sometime in 2022. So first action item, make sure you've removed your gag clauses or that you've reviewed your contracts or are in the process of doing that. Compensation disclosure. This is action number 2 that you need to be aware of today. Section 202 of the CAA, governed under ERISA, has been amended to prohibit covered plans from entering into contracts, renewals, extensions of services for plans with covered service providers without first requiring the covered service provider to disclose in writing any and all direct and indirect compensation in excess of $1,000. An employer's failure to obtain the required disclosures from the covered service providers under Section 202 is considered a prohibited transaction under ERISA, and the Department of Labor can assess fees. Example of covered service providers are your benefit brokers, your TPAs, your PBMs, stop loss carriers. So you can see there's a lot of people involved in your healthcare plan. So what do they need to disclose by 12/27/2021? Remember, this applies to contracts entered into on or after that 12/27/2021. They need to disclose direct compensation, finder's fees, contracted fees, commissions, indirect compensation, compensation that you're not aware of that they may be receiving, transactional fees with a description, and if there's any termination fees. They also need to provide written description of all of the services that they're providing and their fiduciary status. It can be disclosed in dollars, formulas, per capita, and they must provide a good faith estimate because some of these things they won't know at the beginning of the contract. Once employers receive this, you're going to have to determine and deem that they're reasonable. So what is action step number 2? A, ask your service providers for their disclosure notices. And then 2, you want to benchmark their fees and services. Number 3, prescription drug disclosure. Now, there has been deferred enforcement for reporting purposes only until 2022, but you're going to need to report 2020, 2022, or excuse me, 2021 and 2022. You're going to be reporting on the top 50 brand drugs most frequently dispensed, the annual amount spent on the top most common prescribed prescription drugs, the amount spent for the top 50 prescription drugs with the greatest prior year spend, your total healthcare spend, premiums, and rebates. So action item number 3, what to do next? Agreements with your third-party administrator, your PBMs, will need to be revised to allow full access to claim information, rebates, fees, and other forms of information that are going to be required on these disclosures. Again, keeping in mind, the enforcement for reporting has been delayed, but you still should be doing this because you're going to have to report on 2020, 2021, and 2022. Last but not least, action number 3 is the mental health and substance abuse benefits parity. Very complex subject. Again, going to be doing next series or next webinar will be focused on this. Currently, plan sponsors attest to parity on quantitative limitations. Going forward, they're going to attest on non-quantitative limitations. So what to do next? Action item number 4, obviously come to the next webinar. Ensure that you as a plan sponsor have a vendor that can provide this comparative analysis that you're going to need to do. And be prepared to respond to the requests for documentation. I do understand that the Department of Labor is actively asking plan sponsors for this information. So, feeling like information overload, I know I did when I first was told about this. It's much like drinking from a fire hose. With any new legislation, as you know, there are gray areas that we may or may not get full clarification on. Traditionally, courts interpret the regs. The good news is that there has been some precedents set aside from the retirement industry because they've gone through a similar process. So it's kind of like a rinse and repeat of the 408(2) regs in the retirement space. Again, improving outcomes when we're compliant. So where do you go from here? This is a new fiduciary landscape, and you truly need an advocate sitting on the same side of the table as you. Internally, you're going to need to engage and set up your fiduciary process. You're going to want to explore, again, the 2 most important things right now are making sure you have your compensation disclosures from your service providers and that you've reviewed your contracts for gag clauses. You're going to want to benchmark fees and services, plan design, your pharmacy program, and you're going to want to continue this fiduciary process. We like to call it the 5 E's. We want you to get engaged, explore, envision, execute, and examine. It's a continuous process similar to what you do on your retirement plan. And applying that to the healthcare plan not only is going to bring you into compliance, it's going to help to provide better outcomes going forward. This is also not the world according to Jamie Greenleaf. There are lots of resources. I've given you a few here that you can read. And I know that we've put in the chat box, we're going to have a toolbox where we have some information from ERISA attorneys that we've gathered. So you have additional reading materials around this. So I'm going to stop sharing my screen now and open it up to the rest of the panel.
Thank you, Jamie. I appreciate that. And that is a lot to digest. I want to remind participants that you can enter any questions you have into the chat now or later as we go forward. We will have plenty of time for panelists to address your questions. So enter it in the chat. So now let's turn to James Gelfand, who is from ERIC and was the culprit in many ways in helping us to come to this point where we have this bill, which does actually, this law does have great potential for employers. Correct, James?
Thanks, Leah. I don't know if I want to be considered the culprit who did this to everybody, but I mean, listening to the presentation, it's obvious that employers are going to be responsible for gathering just a huge amount of information, and definitely on first glance, it seems daunting, right? I'm surely not the only one sitting here feeling kind of like the dog who caught the car, because we employers, we were like, give us transparency throughout the healthcare system. Okay, well, here it is. This is what transparency looks like, at least the start of it, right? The good news is that I continue to hear that many vendors are offering to help the employer clients comply with the new rules, and that's really good. This would obviously be a bear to do it alone. I mean, there's so much data you would have to gather, and then you'd have to compile it and organize it and host it and create all of these new tools and integrate it with your existing suite of benefits. And it's just a lot, and we get that. And certainly there's some things that I would have done differently if I was writing the transparency rule or the Consolidated Appropriations Act. For instance, ERIC had hoped that the regulatory agencies would allow employers to just fully rely on vendors and just hold the vendors accountable, which we got on some of this stuff, right? On the prescription drug cost reporting that Jamie was talking about, they just issued a reg that said we can trust the PBMs to do this for us, which is great. But we also asked for example, specific information of exactly what is a parity analysis supposed to look like, which they just won't give it to us. They won't, no matter what we try. We would have preferred to just eliminate the whole concept of an advanced explanation of benefits and just let us create a transparency tool for employees that works and not worry about this strange new regime. But, look, if you're on the webinar today, you know that sausage making is just never pretty. That's just how it is. And I think it's worth considering the fact that against a huge wave of lobbying and ad spending and lawsuits from the health industry, we won. Employers won. We beat the doctors and the hospitals and the insurance companies and the PBMs and even the sock puppet employer groups who all were working to try to stop healthcare transparency. And while the compliance regime does sound, kind of awful, the goal was to do something big and to fundamentally transform and perhaps save the private healthcare system in the US. And I know that sounds a little bit dramatic, right? But that is what's at stake, right? If we can't find a way to make the system work and to get costs under control, we probably are going to end up with some version of government-run healthcare. So employers knew we had to do something big, and transparency would be big and transformative. And of course, there's always going to be risks when you make changes of that kind of magnitude. So, transparency is definitely a double-edged sword. We wanted it because we knew that in some ways employers were getting ripped off. And now that we're going to be able to prove it, hopefully we'll be able to change that. and employers won't be getting ripped off, not just from the doctors and hospitals, but also from the countless service providers and middlemen that are engaged in this industry. But the thing is, everybody's going to know now, right? The government's going to know, and in many cases, the public's going to know too what we're paying, which means that we're going to be accountable, not just for complying with all of the submission and reporting requirements that Jamie talked about, but as ERISA fiduciaries for being good stewards of the plan assets. I love that slide that talked about what happened when they started looking into fees in the retirement plans, because that's exactly what's happening in healthcare right now. They're starting to look at and ask questions like, wait a minute, why is this company contracting with an insurance company that's paying 4 times as much to the hospitals for the same exact treatments? And that kind of analysis is happening already, and it's going to blow up in next year. In the middle of next year, when you start putting all this information online, it's just going to blow up. That's going to be hard. There's no question about that. And I think it's going to probably require some very hard conversations with our vendors, because we're going to have to hold them accountable. Obviously, some employers will step in and start negotiating on their own and doing direct contracting. But that's not the majority, right? That's not what most employers are going to do. We're going to have to constantly be benchmarking, constantly be comparing. How are we doing versus the other companies? What are we paying for fees? What are we paying for the actual health care? Are our plans keeping up with the Joneses or not? And we're going to be accountable for that. So, once you've mastered the compliance regime, I hate to say it, but your pain has only just begun, right? Because now you have to start making the really tough decisions that are going to be unpopular. But that's going to mean firing vendors who show themselves to be poor negotiators or who are skimming too much off the top. It's going to mean cutting the cord on providers who are not providing sufficient value, even if it's a famous hospital, even if it's a hospital that right now carries a ton of volume in terms of your beneficiaries and your workers. This is the only way that you create a market, though, right? If there's real consequences for overcharging and for providing poor value, we can take all the data in the world and put it on the internet. It's not going to change a thing unless employers start actually acting on that information. And that's what the regulators want. That's what the legislators want. That's why they started implementing all these rules. I, for one, am personally convinced that this is going to be really good for everyone involved. This is how you can turn the system that exists today into an actual market, and where competition can come from. It will help us to start untangling the knot of all this secrecy and to start figure out what's actually going on. But I think it's also crucially important to think about how we change this conversation to more than just price, right? We talked a lot about looking at the different fees and the different prices that are going to be on there. But what we need to be thinking about is value, right? The cheapest is not always the best. And by the way, the most expensive is rarely the best either, right? We need to think about a future in which we're pooling quality and safety information and combining that with actual pricing data to start computing value. And if you take a long view here, you're not really going to be saving much money if all you're doing is buying substandard care because it's cheaper, or hiring vendors that are doing a terrible job because they're cheaper, right? Transparency can help drive the outliers, like the super expensive hospitals and doctors, towards the median, and maybe get some sort of uniformity amongst what the vendors are charging. But quality and safety need to be part of that if you're going to actually drive value and improve health and better manage health. So, I mean, it's true that the federal government, for now, they're focused on price, right? And they said, we're going to look at quality later. And they didn't say when later is, right? There's always later, it could always come. They tease that this is the direction that they want to go. But the way that I think of the regulatory landscape is one that's always evolving, right? And we know what's coming next. We know that when the regulators feel that they have finished driving compliance with the existing rules on price, they're going to move on to quality. They're going to move on to that. And they've told us that. So it definitely behooves employers to try to get ahead of it rather than wait and see what happens. When that regulatory process starts, the regulator is going to ask, who is already focused on quality and safety, and how are they doing it, and is it working or not? And based on the responses they get to that, they're going to make new rules, right? So if employers can get in front of that and set good examples and show what works, it very well might save us some pain later. And even better, hopefully this could actually, turn things around and take the current system, which is totally unsustainable, and turn it to one that's value driven and rewards excellence and fosters competition and all of that. So I, for one, maybe I'm the culprit, but I'm not sorry, because I do think that this is going to make the system better. It's going to save a lot of lives, and it's going to save a lot of people a lot of money and make them have better lives. So, I'm happy to stop there and participate in the Q&A, Leah.
You're on mute, Leah.
Oh, the mantra of 2021 and 2020 is you're on mute. So no, I thank you, James, and I'm glad you owned up to your culprit self. But I actually, and I know there were lots of compromises made. We didn't get exactly everything that employers might have wanted out of this. And the compliance burden is substantial. So that's why we're here today as well. We have some amazingly good questions too that I want to make sure we get to. But before that we do that, let's turn to Mike Thompson for some comments from the employer perspective, particularly across the country with the coalitions you work with.
Yeah. Well, first of all, I'll just acknowledge I'm neither an expert like Jamie or James, and they're two excellent speakers, a tough act to follow, but I'll just pile on a little bit. It's amazing to me that an act as big as this has flown under the radar in our community. I mean, this is as big an act as ACA, and yet ACA, everybody was all over it. The consultants were all over it. Everybody was all over it. And yet I think it's indicative of where the industry is today, that people really don't want this to happen. They are concerned about when you raise the specter and look underneath the covers that you're not going to like what you see. And frankly, I think the coalitions have been concerned about this for years now. There certainly have been concerns about gag clauses and inability to get information, people saying they don't have the right to their own data. All that's gone. All of it's gone. It was never there before, but now it's codified it very, very explicitly in the law itself. I think increasingly, I've been in the industry for a long time, and I've never seen as much, I'll call it self-dealing within the industry, building business models within business models that allow people to make money that people don't know about. And it's all there. And I think everybody has to have their 60 minutes moment. The 60 minutes moment is, if this was in the light of day, could I defend what I've been doing? And I think that is where we're at. I think frankly, we should learn from the hospital transparency rule, where the law was passed and the compliance is de minimis at this point, right? As this rolls out, the people who are going to be doing the disclosures know what they have to be concerned about and are going to write the disclosures as best they can to defend where they're at and to minimize the amount of disruption that comes out the other end. And so it's imperative that I think plan sponsors know it's on them. On the one hand, this is very empowering to plan sponsors, right? You have the right, but it's also a huge burden of compliance on their part to advocate on behalf of the plan. And I think what happened on the retirement system, that didn't come out just because plan sponsors suddenly started taking a more critical eye. It's because they were getting sued because they weren't taking a critical eye. Can you imagine giving people 350 basis points on a retirement plan? Can you even imagine that? I can't. Well, we already have that happening on the healthcare side, all over the place. And in the light of day, you can't defend what is happening. And I think plan sponsors are going to have to step up at a level they've never stepped up in the past to do their jobs, because it's required as a fiduciary, not because they're going to be excellent advocates for their CFO, but because it's required. required under the law as a fiduciary.
Thank you, Mike. That is a important call to action, I think, for all of us, because it is the employer who is the fiduciary in this law. The buck will stop at the employer, whether it's your fault or not, so to speak. Whoever's fault it is, the buck stops with you. So and the law will hold you accountable for it, but it will also support you in going to your vendors and going to the other third parties to insist that they do the right thing. So I think there's, that's two sides of the same coin, but it's a tough coin for everyone. So I want to add one point before we go to questions, and that is that, it really reinforces something James said earlier about the importance of quality and safety. So obviously I'm coming from Leapfrog, so that is my lens, but it's true that there are problems with the quality and safety of care that are very substantial. They are not minor points. 20 people are going to die in the course of this conversation from a preventable error in a hospital. We already know that. And that is means that you are exposed as an employer when your employees are going to places that are that unsafe, where they are literally, their lives are at risk because there's some lack of safety. And we can inform them in advance of where are the safer or higher quality places to go. And so that issue of transparency that employers have been pushing on, have led on for years in the healthcare system. It's time for that to come into play. That needs to actually have real teeth behind it, because employers, again, are exposed. They're not necessarily the ones that are causing this problem, but they are exposed when the problem happens now. So I think all of the leadership that employers have shown over the years to create things like Leapfrog and the National Alliance and ERIC to really push on the healthcare system to improve its transparency and its accountability, that moment has arisen. And now employers need it. We need all those resources that you created as leaders over the past 20 years. Now it's time to make that work. So hopefully we will all come together and be able to do that effectively. And that's the goal of starting with this series. So, all right, so let me get to some questions. We have I want to start with a question that's kind of fundamental, and maybe I'll turn this to Jamie or James to answer it. It's from Chris Cizak. Suspect the majority of employers are not up to speed. For those that have engaged their health plan consultants and/or PBMs, what has been the reaction to compliance? Seems the burden for compliance should fall on those actors and not on the employers. Do we really think these middlemen will comply willingly with a fight? Where does that leave the employer who's trying to comply? Yet another lawsuit? Jamie?
Oh, yes. Unfortunately, most employers are not asking the right questions, so they're getting the wrong answers. It is very important that you ask the right question. We need our new disclosures that are required under the Consolidated Appropriations Act. And when they're sent to you, one of the best practices may be to have that service provider attest to those compensation disclosures, keeping in mind that it's not just about fees, it is about what services they're offering and if they're in fiduciary status. Regarding the gag clauses, and you will get pushback, but you need to move forward with it. And again, in the toolkit that we gave you, we provided you with some legal language that you can use to really push the provider to give that information. If you don't get that information, if you ask for it in writing and you don't get it, as an employer, you have to report them to the Department of Labor, and you need to start process for terminating their contract. Otherwise, you are engaging in a prohibited transaction and can be penalized by the Department of Labor, substantially penalized. Regarding the gag clauses, the best thing that you can do is to get a hold of your contracts, because you'll be amazed. I just sat with an employer who provided us with 5 contracts, said, listen, we're with one of the big brokers. I'm sure there's no gag clauses in our renewal contracts. We found 8 of them, 8 gag clauses that prohibited them from accessing the data that they needed to receive in order to provide their fiduciary duties under ERISA. So you need to receive your contracts, you need to go through it with a fine comb to determine if there are gag clauses, and then you need to strike them and send it back saying this needs to be amended to again, comply with the Consolidated Appropriations Act. You may actually ask them to attest to it as well. So again, yes, the burden lies on the employer, but you now have the legislation behind you to actually promote them to do the right thing. And in doing so, the benefit is to you and your employees. Remember, transparency is not good for everybody, but it is really good to us as the end user.
And I think one point to emphasize that you've talked about with me in the past, Jamie, is that part of the compliance as a fiduciary is the process you undertake. It's being very thorough about a transparent and wide-ranging process. Ultimately, you can't guarantee that everyone pays attention to everything and does everything they're supposed to be doing. We just, as human beings, we can't do that. And the law even doesn't expect that. But we do have to take much greater steps than we have in the past. Okay, here's another question. What will employers do in areas with little competition from hospitals, physician groups, hospital-owned physician groups, et cetera? What's going on with telehealth that maybe could help with some of that? So like a rural area, I guess, or somewhere where there's very little competition. Actually, that's pretty much the whole country now because there's so much consolidation. But James, you want to take that on maybe?
Yeah, I mean, I'd say look for travel benefits to go to the moon in a big way. I mean, you all have heard of Walmart and some of the other big purchasers that for a long time have done centers of excellence and things like that. That's going to be the new way forward. There's no question about it that when prices are revealed and when you start to see that there's no justification, there's no quality that justifies the prices being so high in a specific market, employers are going to be accountable for saying, well, what did you do then to create competition? Did you take the people out of that market? Did you take providers and put them into that market, right? So you've got a travel idea or you've got telehealth, one way or another, you have to create that competition. You can't just say, I don't know, there was nothing I could do. I'm just the purchaser spending billions of dollars. I didn't have any options. You know, and similarly, actually, to what Jamie was saying, you know, your vendors are going to come back to you and they're going to say, oh, there's nothing I can do, right? They're the only hospital in town. I just had to do it, right? They're going to tell you, oh, I have to have this gag clause. The hospital insisted on it and the drug company insisted on it. None of that is going to get you off the hook with the regulators. Remember, they're allowed to tell you as the employer, they can tell you that. Oh, well, I had to do this. There is no choice. But then you will be held accountable for it. So you have to hold them accountable for the lack of competition in markets, for the lack of efforts to eliminate the gag clauses, et cetera. You know, we can talk about later what happens, you know, does this mean there has to be lawsuits, et cetera. But for now, I think it's important to know you do need to be thinking about ways that you can kind of break those monopolies in those areas where you're essentially lighting money on fire, because prudent ERISA fiduciaries don't light money on fire.
I'll just add, so think about in the retirement space 20 some years ago, if you wanted a Fidelity fund, you had to be on Fidelity's platform. If you wanted Vanguard fund, you had to be on Vanguard fund platform. And the reality is when employers determined that they had a fiduciary duty that was over and above benefiting Fidelity or Vanguard or any of the others, I'm not meaning to pick on those specifically, all of a sudden things started to happen, changes started to take place. At the end of the day, you might as well say guilty if you didn't push your service providers to do the right thing and or terminate their contract. Because it's going to be you as the employer, not them as the service provider. They may be pulled into it, and I think you're going to see that just like you did in the retirement space. But at the end of the day, I think, as Leah said it best, the buck stops with you. And you're offering a benefit that comes with liabilities, and those liabilities have just been, you know, pushed up because now you've been able under the legislation to access the data that you hadn't been able to make good decisions, and now you are, and you need to take that on. And it does feel very cumbersome, but trust me, you're way ahead of the market. You're on a webinar learning about this. There are employers that have no idea the freight train is coming. So you're way ahead of the curve.
Yeah, can I just add in there?
Sure.
Put myself in the shoes of the benefits professional who's trying to figure out, what do I do when I only have one hospital in a location? I don't think it's as simple as, oh, we can send everybody across the country. It just isn't, right? But I don't think you can just sit there and take it, particularly when you get disclosures that are totally out of whack. And I think this is where engagement through coalitions, through other organizations, and frankly, openness to regulatory involvement and others. I mean, if the plan is being abused by providers that are insisting on things that cannot be defended, then I think everything has to be on the table on how to deal with that. And if your intermediary can't get it done, you have to be open to other avenues as well. And we know that the horse is out of the barn in some of these locations. And frankly, everything has to be on the table, including regulatory oversight. If that's what it takes to bring this thing back into rational behavior.
Okay, well, that's a tough challenge. All right, so I got a lot of questions. So let me ask. I think Jamie probably is the right person, but if not, John, my other panelists, jump in. My carrier TPA regularly supplies us with claims data. Does that imply our plan contracts do not contain gag clauses? And does this mean admin fees, PEPMs need to be itemized? And how does it apply to fully insured versus self-insured plan sponsors?
So the Consolidated Appropriations Act applies to both fully insured and self-insured employers. Don't think that I'm fully insured, I don't have to do anything. You do. You still have, there are some safe harbors on some pieces of this, but you still have to receive disclosures, determine reasonableness, have a fiduciary process for determining if the plan that you have set up is actually in the best interest of the participants. Self-insured have a little bit more data that they need to dig into. If you are receiving information from your carriers, your PBMs, your TPAs, that's great. That doesn't mean that they don't have gag clauses. That may mean that they're providing you with data, but you cannot use that data to go out and shop for lower costs, higher quality. So you need to review all of your contracts, and you may find that your contracts with your TPA and your PBM have gag clauses where they can't share the information that they've received together with you. Remember, this is your data, your information. You now have a right to access that for any purpose. Benchmarking, very important. Determining quality, also very important. But I would say 99.9% of the contracts we've looked at have a gag clause. So just because you're receiving some data right now doesn't mean you don't have gag clauses. You may be restricted on what that data could be used for.
Okay, thank you. We have a request for questions we should be asking, toolkit questions we should be asking. Do we have that available? Or is that something still under development that people will have to ask their consultants about?
Within the toolkit, we've provided you with some legal opinions around each piece of the puzzle that we've spoken about today. Within those kind of commentaries, you're going to find things that you may need to, think about in asking those questions. Again, similar to what you're probably doing on your retirement, you have an advocate that sits on the same side of the table as you, and you kind of outsource some of that fiduciary responsibility. That's the trend we're kind of seeing here is, hey, I'm an employer, I'm trying to run my business. I need somebody to come in and kind of really help me put together a prudent process and determine where my liabilities and risks are and turn those into assets as opposed to liabilities. And that's one of the things that we do. But I think that there'll be some pieces that they can get questions from if they want to do it themselves.
Okay, great. Thank you for that toolkit too. I have to say, I do appreciate TILT. I mean, you have There's nobody on this call is, by the way, been paid to be on this call, and none of us are getting paid to follow up on it. This is all about a service to you. So I appreciate that, Tilt, for the research you've done and the information that you're helping us to recognize as urgent for employers to understand. We have a couple of questions about quality, and I'm not sure we're ready to answer them all yet. So the proviso, because we're all learning as we go, because there's so many issues around how this law is implemented. But can you address quality? And is there something in this legislation that requires providers to redo procedures they have experienced a complication on? So this is like a never event where there's a complication, or providers collect twice when there is a complication or infection or readmission or failed procedure. Are we ready to answer that? Let me put it that way.
I mean, Leah, I wish that was in the law.
Right.
Unfortunately, it's not. I mean, this should be subject of your private contracts, though, right? Like, these hospitals should have agreed to the Leapfrog principles, which said that if they made a medical mistake and committed a never event, that they should solve the issue at cost to themselves, not to you, and the patient shouldn't have to pay anything, etc. But we haven't got that passed into law, unfortunately. I mean, it's one. I mean, the question has a good example that says, if this happens basically in any other industry, it's on the vendor to fix it, right? Like, if the mechanic screws up your car, the mechanic fixes it. He doesn't tell you that you have to pay him for screwing up the car and to fix the screw up that he did. But I think it's just one of many examples of ways that we have just allowed the healthcare system to get completely out of control and have its own set of rules, right? Like, for instance, you can be treated by a very junior doctor, and then your health plan will be billed at the rate that the senior doctor would charge. That's illegal for lawyers to do, right? Like, if the junior associate spends an hour on your case, you can't be billed for an hour of the senior partner's time. That would be fraud. But we've legalized fraud in the medical industry. And it's just, there's tons of examples of this. And we got to go through, I think, one at a time and find these examples and stamp them out. The CAA didn't get everything done. It got a foot in the door so that we can start to see what's going on. And you're going to be able to at least see what those prices are. You're going to be able to get an estimate beforehand, and you're going to be able to look at the variance between what was the estimate and what was the charge and why was it there. I think Leah can tell you that there are Leapfrog members who have done that kind of analyses on their plans, and they found some weird variances there. They found some instances where the hospital should have said, you know what, we made a mistake, but they didn't tell. They didn't do anything because nobody had opened the books on them before. So when we start opening those books, we can hopefully start to hold those providers accountable in this way.
And when bad things happen, again, the fingers are going to be pointed at the employers no matter what. So even if it's not anticipated in the law, like something like this may not have been anticipated in the actual language of the law, I think for employers, there's still going to be something major to worry about, if nothing else, because they care about their employees. That's a major thing, but also because ultimately that is the complication with healthcare, is that there are so many complications in healthcare. And that's a little bit different maybe than a 401k plan, where this is about people's lives that they're making decisions about, and you're going to be the fiduciaries. That's tough. So we are almost out of time, and I want to give one question to Mike, and then we will, before I give that question to you, Mike, we are going to be following up with you with resources, materials, and that toolkit we mentioned with some questions, as well as we will be making this webinar available, a tape of this webinar available. And then we will also send you information about follow-up on many of the different issues in this. For instance, we haven't even touched on mental health parity, which is a major issue in this legislation, and a whole new level of fiduciary responsibility. So we want you to be aware that we'll have a webinar on that coming up. So, but the question from Mike, from one of our viewers here is, how can regional coalitions help? How can employers use this to better execute their health strategies? So big question. Any quick answer for us?
Yeah, just quickly, anytime you're dealing with supply chain type activities, and that's what this is, right? You're dealing with your advisors, you're dealing with your intermediaries, you're dealing with providers in the community. I think there's a lot of value in coming together with your peers and working together to promote a higher value system, a higher value, more transparent system, and all of that, and sharing on that. In addition, frankly, some of our intermediaries or even advisors may themselves be subject to this, and you're going to need advice from an independent source. And I think the coalition served that very effectively. And so I think the coalitions are important. I think it's also important to know that, and I think James and Jamie set this off, this is such an opportunity to execute strategy more effectively. You've been empowered to ask for the right information and then to look with very discerning eye what value is, and to gradually get this thing correct. And I think this is, you know, it's certainly a responsibility, but it's also a huge opportunity to integrate it into your strategy and to execute with that in mind. And plan sponsors have never been more empowered or more relied on to drive the system. And this, I think, is going to help coalitions support them even more effectively.
Great. Well, that's great words. Don't go it alone. That's fundamentally why the three of our organizations came together today. We aren't going to go this alone. This is a big one, and we're going to meet this challenge head on, and we're all going to be better off for it. So that's the goal. So please stay tuned. You're also going to get a questionnaire on how this went today. And so I encourage you to complete that. We really do need that feedback as we go forward with more webinars like this that hopefully will keep you up to date and as effective as possible in addressing this extremely important and urgent new piece of legislation. So thank you for joining us, and sign up for our mailing list, and we'll keep sending those resources to keep you on top of it. So from the Leapfrog Group, I'm Leah Binder. Thank you.
Thank you.